Okay, good morning. We're returning on April 1st, and I appreciate the witnesses getting back here a little bit early. We were scheduled for 10:15, but we finished up the adoption bill a little early, so we're gonna jump right now to civil forfeiture, H533. And our first witness is Tucker Jones, Assistant General Counsel, Department of Public Safety. Welcome, Tucker.
Thank you, Mr. Chair, and good morning,
We
Senators.
had a walkthrough with Ben the other day.
Yeah, right here.
Go ahead, sir.
Yeah, good morning. Thanks for the opportunity to address the committee this morning. My name is Tucker Jones. I'm Assistant General Counsel with the Department of Public Safety, here to discuss H533. I have discussed this bill with Lieutenant Daniel, who's here as well this morning, and Major Trudeau at the State Police. And Lieutenant Daniel and I testified with House Judiciary on this bill, and we had the opportunity to meet with Legislative Counsel about it. And the State Police are open to help operationalize some form of a state forfeiture process, but there is concern about limiting Vermont law enforcement's ability to use the federal adoption process as it's limited in this bill on pages 20 and 21. So it's my understanding that the existing state forfeiture statutes in Vermont are rarely used today, consistent with what Evan was testifying to last time you discussed this bill. And law enforcement generally uses the federal forfeiture process on a more regular basis in Vermont. And from the law enforcement perspective, there seems to be two reasons for this. The first is that the federal forfeiture process does have an effective operational process in place to transfer and distribute assets. And Sheriff Marcoux testified in this committee referencing the federal forfeiture manual, which is 200 pages long. And there's just a robust process in place to handle the actual mechanics of the transfer of funds in the federal system. And VSP has tried to use the state system in the past, but was not successful in doing so. The state police did not ultimately receive the funds out of their contribution into the state system when it tried a few years ago. This bill makes significant changes to the state process, and VSP wants to make sure that the process just can be operationalized effectively for all the government entities involved in the handling of the actual funds. The second reason that the state system isn't used very much today is because the system as it exists today, the statutes in place, as well as the proposed statutory changes to the state system, ties asset forfeiture to a criminal conviction or some form of a cooperating witness. And this bill, in addition, shifts the entire asset forfeiture process into the criminal division. And I've spoken at some length with Lieutenant Daniel about this. And he's explained to me that there are not necessarily criminal charges associated with legitimate asset seizures and federal forfeitures. And the typical example of this is in circumstances in which the cash is seized from a courier for a drug trafficking organization, and no criminal charges are filed against that courier because the real criminal target is elsewhere, often out of state. And he's here this morning to speak in more detail about that type of circumstance. But under this bill, seizures of less than $25,000 that are not task force cases would no longer be able to be processed under the federal system, under federal adoption. as I mentioned on pages 20 and 21. And so federal adoption is when a municipal, county, or state law enforcement officer seizes assets and submits it to a federal agency for asset forfeiture under the federal forfeiture process. And law enforcement has concerns, the state police has particular concerns about limiting the use of federal adoption for asset seizures in Vermont. It's my understanding that the origin of the proposal to limit the use of federal adoption is the reported misuse or abuse of the federal system by agencies in other states. Nevada, I think, was given as one example, but there are other examples as well. And in my conversations with Lieutenant Daniel, we're not aware of any misuse of the federal adoption process in Vermont. So the state police does not support limiting the use of this tool in Vermont. Another premise of the bill is that a criminal conviction.
Tucker, can I ask you a question?
Yes.
What would we need to do to this bill to make it work? I can remember writing the original civil forfeiture bill. I can't tell you what day, what year, but I can remember drafting it. I think it was during the Shumlin administration. And we were trying to deal with the trafficking of drugs into Vermont with less money involved than might have been involved in federal cases. So the feds weren't interested in those, in that Corvette, but they might be interested in 250,000. But these were smaller amounts. What can we do to improve the current ability in Vermont to have either the state police or a municipal police department able to conduct forfeiture? I would prefer to improve the current law to make it more usable and rely on the federal forfeiture statute for those larger, where the task force has been involved with the feds, for example. Does that make sense? Does that question make sense to you?
It does, Senator Sears, and we were fortunate to have a conversation between myself and legislative counsel and Lieutenant Daniel about what the concerns are. And the primary concerns, as I mentioned, is just this limitation on federal adoption. But as to the state system, the real crux of the matter appears to be this narrowed requirement in the existing system and in the proposed system that there's some criminal conviction or cooperating witness associated with the seized assets. And from Lieutenant Daniel's perspective, that's just not always the case. It's not always forthcoming that we have a criminal proceeding associated with a legitimate asset seizure. And, there's a desire, a policy desire to tie those two together. And there are, of course, circumstances in which the person who has the cash is arrested for a related offense. But we just don't necessarily have a cooperating witness or a criminal proceeding in all of the circumstances, especially when we can identify that the person who's transporting the money is in fact essentially a victim being used by the drug trafficking organization as a courier on their behalf. And so that's I think has been a persistent hang up in our conversations about improving the state system. And it's I think there's a kind of ideal policy goal to tie them together. And then this practical kind of observation from the law enforcement side that it just isn't always forthcoming that in legitimate seizures, they are tied together with some criminal proceeding. And so from Lieutenant Daniel's perspective, there's a real openness at the state police to try again to use the state system and to make it work. But we're flagging this issue of we just may not have a criminal case associated with it, with a legitimate seizure that they want to process. So I think that's kind of what it comes down to as it relates to the state system.
from my perspective, and maybe hopefully the committee, our goal is to make something that works and not pass something that doesn't work.
Right.
And the state police share that because they have a particular interest in making sure it's operational, because they want to be able to process assets through it. And so, we were, and are continuing to be open to testing it through test cases to the extent that the committee does ultimately pass some form of a revamp of the existing state system. Lieutenant Daniel has expressed openness to putting test cases through it to see how it works and working with, the Treasury, who I see is here today, just to coordinate the communication to make sure that the state system is effective.
Okay. Ben, do you have language yet from?
Well, Ben Novogrosky from Legislative Council, and to reiterate Tucker Jones's point, we had conferred about some of these concerns while it was in the House, and there was an addition of, especially in the federal adoption portion, of the defendant, owner, co-owner, or regular user language, which theoretically, and again, if this doesn't fully address the concerns, I'm happy to continue working with Tucker, but that sort of a restriction. So technically a courier, I think the situation obviously depends on the facts of the case, but probably would not be considered an owner, co-owner, or potentially defendant, regular user of the property that's seized. So arguably that situation would fall outside of the restrictions of this. And I would believe give law enforcement the leeway that it's seeking here. And then as far as and that language is pervasive throughout the bill here. And so these hearings aren't even prompted, the post-seizure hearing, the lien holder hearings, or the defendant's hearings, unless they qualify as defendant, owner, co-owner, regular user. So again, that language was used to try and tailor this so that law enforcement had the flexibility in those situations where a courier may be used, or some other individual that wouldn't fall under those definitions.
Senator Bruce.
I still have concerns about that regular user language. It just feels very squishy to me. And I'm used to, in cases like this, ownership being a defining thing, familial relations being a defining thing. So, somebody's the spouse of the owner or whatever, but somebody happens to be using the car, how do they acquire the ability to shield that asset? I mean, I understand it's meant as a compassionate addition to the law, but it seems like it's reaching for something in a kind of murky way.
Yeah, and with that in mind, I mean, admittedly, that language was taken from the current statute as it exists, and I think it would meant to be a fact-specific inquiry within the court so that it wouldn't unnecessarily exclude people that may be unduly impacted by forfeiture or seizure. That being said, I can make some attempts to try and refine it a bit more, or depending on what the committee views as sort of the proper scope of
I
that.
think what we don't want is the innocent owner losing their vehicle or whatever property. So for example, if somebody borrows my car and they, unknown to me, use it for illegal purposes, should I lose my car? Should my car be forfeited? That, and I had no part of it. Now, I'd like to protect the innocent owner. But if I'm a courier for somebody in Springfield, Mass, carrying 25,000 up here to buy guns to, take back to Springfield, I may not have committed a crime by carrying 25,000, but if they can prove that this was part of an illicit operation, and seize the 25,000, and I think that's legitimate. But
I was just laughing because I was thinking of, we loaned our car to somebody, and we had no idea, and he was picked up for drugs. And the car was impounded. We got the car back, but all over on the gas tank and all the doors and everything, there's this tape that you cannot remove that says, use it, do not remove, use as evidence or something like that. It's all over our car.
Kind of a badge of honor.
Sounds like you have a case. I'd go see a lawyer. Anyway, is that kind of the goal here, Tucker?
That we would be, open to working on, trying to adjust this language to make sure the state system kind of accounts for that scenario that I just described. But the state police don't support removing the ability to use the federal adoption system in the meantime.
Right.
In short, at a minimum, the state police wants to make sure that the state system works in appropriate circumstances.
I think we understand the goal here, and maybe if you could work with Ben on the language, that would be helpful. And if we could hear from Lieutenant Daniels. And I do want to mention for the record, neither of our cars would get you much. I don't know Senator White's car, but I know my car. Neither of those cars would get you much on the market today.
Mine wouldn't have gotten them anything. They probably would have had to pay to get rid of
Our
it.
use of examples.
Yeah.
Lieutenant Daniel? Oh, did you have more, Tucker?
No, that's all right. Senator Sears, that's fine. I think might be best to hear from Lieutenant Daniel now.
Lieutenant? Well,
Good morning, Senators. Thank you for inviting me to testify. For those of you who don't know me, my name is Casey Daniel. I'm a lieutenant with the state police. I'm the commander of the Vermont Drug Task Force Narcotics Unit. A lot of my testimony today was to kind of give the committee an idea of what is actually happening on the streets currently within this continuance of the epidemic that we've dealt with for several years now with this opioid crisis, and specifically the increase in violence and homicides that are all attributed from drug trafficking and law enforcement's lack of ability to kind of get a hold on some of these situations. I did want to just touch briefly on a question, Senator Sears, that you asked Tucker, was some of the things that we'd be looking for. And I think something to look at for law enforcement in a state system that's going to work well is looking at the percentages sharing. In the federal system takes 20% for the processing. As of now, and 80% goes back to any of the agencies, including state's attorneys and other divisions that were involved in the case. And as it's written in this bill, it would be 45% going back to the general fund, and the remaining funding would be split amongst a variety of different stakeholders. So I think that is something to consider from our perspective anyway, in addition to what Tucker testified to. So a lot of the cases that law enforcement deals with in Vermont are long-term drug investigations that have a direct connection to drugs, and there's a connection to the cash that are seized in a lot of these instances. And many times criminal charges for these individuals are not present or appropriate at the time that a seizure may occur. It takes time to investigate that further and to really work the case post having the monies seized or assets seized. There obviously still needs to be based on probable cause, and law enforcement needs to show a relationship from the property to the alleged offense. a lot of times, well, there's several instances where we get a lot of tips through the tip line, through law-abiding citizens or confidential informants about specific times, dates, locations that drug trafficking organizations are moving money and or drugs. So law enforcement acts on these tips if they can validate it through other means of investigation. And these drug trafficking organizations are getting smarter and smarter. They're not putting their drugs with their cash, and they're using couriers to move it for them because they know that they don't want to be associated with that money in hopes that it's not going to get seized, and it separates them from being there. And these people are typically unwitting individuals, opioid dependent individuals that receive drugs or money for moving their money or drugs for them. So we run into those situations, as Tucker alluded to, where there really isn't an arrest. We have a victim transporting money for these individuals. I wanted to just touch on last week, the Defender General Office spoke about the threshold limits, and we agree too that the limits are pretty low. They should be set much higher. We found out through our experience with the federal system that these smaller cash seizures actually cost the government more money to process than it does to even get those monies back into circulation to continue fighting the crimes that we're trying to fight with that money. So those limits, $2,500 cash limits possibly, or 10,000 for vehicles, seem to be what we typically try to focus on, unless there is a direct arrest attached to those vehicles or cash. That may change a little bit. The other thing that we're seeing in the state is quite an influx in the motels, rental properties that are being used by these drug trafficking organizations. And one of the most difficult things that law enforcement has to deal with is receiving these daily complaints from law-abiding citizens regarding drug trafficking in their communities, and repetitive complaints of the one house in the otherwise quiet neighborhood that's consistent drug trafficking and criminal activity. So this is a challenge because there's not a lot that law enforcement can do about these things. One, resources, and there's just so many of them. I probably receive 5 of these phone calls or emails weekly from different places around the state. As far as asset forfeiture, we're not always receiving monetary compensation for these forfeitures, and I want to just point that out. There's a couple incidents in Rutland in 2015, investigations, one being on Park Ave in Rutland City. I've been receiving complaints with pretty much the whole area was infiltrated with drug dealing and violence. And there were, after a lengthy investigation, there were 3 multifamily buildings seized in the U.S. Attorney's Office. We didn't move forward to sell the properties for profit, but instead, those properties were donated back to Rutland City and were restored by a local nonprofit as single-family affordable housing. And this completely reconstructed the neighborhood into a safe, drug-free community. There was another investigation at 24 Cottage Street in Rutland City that was ultimately seized for forfeiture process. And this kind of alludes back to your reference with, borrowing somebody's car and having that car seized. The son of the owners of the property was heavily involved in drug trafficking and had been arrested several times. Ultimately, the property was seized, And through litigation, the U.S. Attorney's Office ended up dismissing the case in an agreement that the current owners sell the property to an uninterested party, and that uninterested party would restore the property to mitigate the drug presence of that property. So I just wanted to highlight those couple of investigations. So in Vermont, amongst other parts of the country, this opioid epidemic is continuing to increase. Drug traffickers from surrounding states such as Massachusetts, New York, and Connecticut capitalize on selling drugs in Vermont because of the substantial price markup, and that Vermont is perceived to have weak drug laws by these drug trafficking organizations. In a city such as Hartford, Connecticut, a bundle of heroin or fentanyl, that's 10 bags, costs approximately $20 to $30. And these folks are bringing it back up to Vermont and selling it for $100 to $150. The drug traffickers know that the demand and the amount of money that they can make up here, and they inflate the prices to 400%. Law enforcement struggles to keep up with this increase in opioid use in Vermont since the start of the epidemic in 2014. Vermont opioid deaths are up over 70% in the last year, according to the CDC. Violence, drug-related homicides, and shootings in the state has also increased dramatically in the last couple of years. These drug trafficking organizations consist of young violent offenders that have exhibited hellacious acts of violence within Vermont. And the reason I bring this up is we feel that by limiting the tools that law enforcement has to combat these individuals, that this problem is just going to get worse. Referencing Bennington and the experience that the law enforcement is going through down there now, it's increased at an alarming rate. In March alone, there were 6 shooting incidences in Bennington. And I worry with this bill, without making some changes, the local law enforcement, such as Bennington Police, would be limited to seize assets from the drug traffickers to make it more profitable for them to stay. Interestingly, in 2020, Bennington PD seized just over 7,000 bags of fentanyl. In 2021, they seized almost 40,000 bags. Asset forfeiture in 2020, Bennington seized around $11,500 in assets, and in 2021 was $38,500. So it's a dramatic increase in just 1 year in that area. Drug traffickers adapt to laws and are very conscious to separate the transportation of drugs and bulk cash. As I said before, there's less risk of money seizure if there's no drugs with the bulk cash. And these drug organizations know that. And they go to extravagant lengths to separate these.
Okay. Questions?
So yes, there's, and the Vermont residents in September of last year, state police arrested a female Vermonter with 160 grams of crack. And this female cooperated, and during her interview, she indicated that she was forced by these drug traffickers to run drugs to Vermont because of her large drug debt. This female was threatened with physical violence directed at her and her family, to include small children. She also stated that numerous times she had not only transported firearms to Massachusetts for these drug trafficking organizations, but also had brought down hundreds of thousands of dollars in cash throughout many trips. So we're clearly only touching the amount of cash and drugs coming back and forth out of these states. We all know that Vermont's not a source state for narcotics. We're a consumer state. Drug traffickers usually come up weekly, and in our estimates, from what we're seeing, is they'll profit between $10,000 to $20,000 a week. Once they're up here for a week, they get the money back down to their home state, and then the return trip with more drugs. It's important to remember that drug trafficking organizations sell drugs for one sole purpose, and that is to make money. Seizing their assets and holding them accountable in the criminal justice system deters them from continuing this endeavor. Most importantly, we need to find a way to significantly reduce the demand of opioids in the state. This is potentially our best defense to deter drug traffickers from continuing to come to our state and take advantage of Vermonters that are vulnerable to their motive. We feel limiting law enforcement opportunities to seize drug traffickers' assets is going to strengthen their organizations. So in closing, from a Vermont law enforcement point of view, we fully support oversight and accountability to ensure that no law-abiding citizens are victims of poor forfeiture practices. We believe that this is not happening in Vermont, and if it did, our current state, federal asset forfeiture rules and policies are in place to protect these Vermonters. I understand the purpose of this bill and value the committee's intent to protect Vermonters. And I'd be happy to answer any questions if there are any from the committee.
Yeah, Senator White has a question.
Well, I'm trying to relate what you have been saying to the bill itself and how, what we need to have in here and what we don't need to have in here. And I just, I don't know if I'm interpreting this right or not, but the one thing I did pick up here is that you said you don't want to do anything that's less than $2,500 or $10,000 for a car, but in the bill, it says less than $200 or less than $2,000 for the value of a car. Is that something we need to change? I mean, I'm trying to figure out how what you said relates to the bill that's in front of us.
Yeah, our perspective on that is just, and that's from experience, is, you know, by the time that the processing is all done for these forfeitures, it's not going to be worth anybody's time to, even $1,000 is really going to be really hard to justify the amount of time it's going to take to go through that forfeiture process. And
so should we change that to $2,500 and $10,000 for the value of the car? Or
that,
I mean, I'm trying to figure out how we change the bill here to make it
somewhere in that ballpark, I think would be safe. And then maybe a provision if, like I had attested to with a direct criminal connection or a criminal arrest, if that's involved, which under this bill would have to be involved, it could be lowered, but we typically don't seize anything less than, you know, I think $1,500 is very rare to seize that low amount of cash.
Okay. Thanks. Yeah, I'm just trying to figure out here what is in the bill that shouldn't be in here and what isn't in the bill that should be in here so that we do the right thing. And I'm having a hard time putting your comments into the bill itself.
I think those amounts that I referred to are sufficient amounts, and they should be higher than what is in the bill now.
Are there other things in the bill that we need to address?
I feel the taking out the civil forfeiture is going to really put a strain on law enforcement.
Where is that?
Ben,
That's the whole bill.
Go
That's
ahead.
the whole bill.
Yeah, so I think what I'm hearing when Lieutenant Daniel says that is that this converts basically eliminates the civil forfeiture process.
Okay.
And that's what this bill would do.
Okay.
What was the,
So why-
dumb question, what was the point of the bill?
Yeah.
Well, there was a lot of testimony, and I do know Lee McGrath can speak to the impetus more in detail, but there was testimony just about creating a fairer, more efficient system within the courts, one that would provide mechanisms for owners and innocent owners and lien holders to seek return of their property. And also there was testimony that the House Judiciary Committee heard about defaults that often occur within the civil process because the criminal process oftentimes for defendants is the primary concern. And so civil forfeiture is sometimes an unintended consequence as a result of, for lack of a better term, sort of being deprioritized.
I've got to ask a question. You know, when we hear all the witnesses, I'm happy to make that decision, but maybe we're better off doing nothing.
Yeah.
And that is definitely a policy decision for the committee. But again, I would just say Lee McGrath, I know, has good information on the underlying reasons for the bill itself. Right.
Okay, but just ask
Yeah,
one
go ahead.
question. Couldn't we just do a process for people to have an appeal process for innocent people to get there without doing this whole
Well,
thing? I guess that's my question.
and there are processes worked in to the current civil forfeiture statute that would provide a basis for this. But again, the testimony was that combining the process out of some due process concerns for the defendant, where forfeiting property altogether really implicates property interests. And so ensuring that those property interests are given their proper due in the proper forum, in addition to maintaining and potentially expanding those other mechanisms for the return of profit.
So, but I still come back, the current system is not, state law is not working. That's what the testimony from law enforcement was, I believe, from Tucker and the lieutenant. So if current law, if we're going to do anything, then we should improve on current law to make it work. I mean, this came, it's interesting that Lieutenant Daniel talked about Bennington, because part of the reason for the bill in the first place was in Bennington. We had a problem, I think, might have been the first or second year of the Shumlin administration. So I'm trying to think of when we rewrote the law back then. And if this is not working, then I'd like to see us update the current law. But on the other hand, if what this was designed to do was changes to current law that isn't working, I don't know the point of changing it. I
And
don't know if that made any sense, but
Made sense
it
to
is
me.
Friday the 1st, so maybe that's why it makes.
no April Fools today, right?
But
Oh, right here.
why don't we jump to our next, are there any other questions for Lieutenant Dan?
No, thanks.
Senator, yeah.
And just quickly, as far as, from what I heard from the testimony, is that part of the issue as far as the system being unworkable is actually receiving the funds after they've been forfeited, and I think the treasurer's office may have some good insights about why that happened. And just telegraphed a little bit is that under the current law, there's the Governor's Criminal Justice and Substance Abuse Cabinet, which is sort of the distributor of those proceeds. It hasn't been in existence. And so the law, one of the changes that this law makes is making the state treasurer in charge of distributing. So
Because the Justice Cabinet no longer exists.
correct. So it
Which
may
I was
help.
a member of, but oh, there you go. But I wasn't even notified that no longer existed. I think I still get appointed to it, and maybe that's something for just to check on Ben and see if there's still a Senate appointment, House appointment to the Justice Cabinet. Because if it no longer exists, I don't want to be on it.
Yeah, no, it's not in existence anymore, so I'll check that.
But if you could just check that,
Sure.
I think I'm still on it, according to the Senate. I wondered why I hadn't been invited to meetings in a while.
Per diem stuff.
I thought it was something. Anyway, our next witness is Judge Zone, but I don't know if he has any comments, given what we've just heard.
Well, I have a question from what I've just heard, and Tom Zone, Chief Superior Judge. My comments, I've got quite a few actually, but they go in, if you will, to the weeds of the language and the workability of it, and areas that I looked at and that others have looked at and had questions and concerns about for how we would implement this. And so I'm not sure if you want to hear from me at this point, go into that, given your comments. I would point out that I did ask for some statistics, and I'm told that in the last 5 years, we have had 20 civil forfeiture cases filed in the courts. 14 of them are still open today. And as far as those 14 of them, 9 of them are seeking to seize motor vehicles based upon our DUI and DLS statutes. 4 of them are seeking to seize animals, and 1 of them involves drug proceeds. So I don't know about the other 6, but that's the only That's what I am told we have for statistics. But again, I can get into the weeds on the specifics of the statute and how it would work, or I can be here as an answer
I think
afterwards.
the bill is, if we go forward with the bill, it's gonna significantly change. But if there are some things in the bill that are not workable for the judiciary, we'd like to hear.
Okay, then I can address that. In terms of the bill, first of all, if you look at on page 5, I would go to section 4242 small a. Prompt post seizure proceedings. This provides a right to a prompt post seizure hearing, and there's obligations to provide notice to owners, co-owners, or other users of property. However, the statute does not identify what those notice procedures are in that section. It doesn't tell us how we provide notice. I would note that subsequently in a later section, 4243D, it talks about notice. And so if we're going to have notice procedures in 4242A, I would suggest that perhaps there be a reference to maybe 4243D moved up so that we're all clear what is the notice that we have to follow.
Right.
And one of the things it says in 4242A is that one of the grounds for return of property at this prompt post-seizure hearing is that a criminal charge has not been filed and no extension of the filing period established has been available. However, 4242A doesn't define the term filing period, as far as I can tell. So it says, well, you've not done it in the filing period, but it doesn't tell us what the filing period is. Is it the statute of limitations for the charge? If so, it would be 3 years, for instance, for a misdemeanor. And so it's unclear what is meant by that as far as the filing period. If you then go to section 4243, which is on page 6, it begins. It talks about service of the notice is required pursuant to the rules of criminal procedure. And then what happens is the rules of criminal procedure, I would advise, actually references under Rule 49B, they reference the rules of civil procedure. And so in this case, a defendant is going to actually be represented by counsel, or they'll be self-represented, and they'll have notice of the pending charges. Other people with an interest in the property are effectively potential parties to this criminal proceeding now. And so I would suggest it may make sense to actually require personal service on those people, because otherwise it's questionable as to how you get service, because under the criminal rules, notice to the defendant's attorney will be sufficient. However, the criminal rules don't address interested party service. And so it might help to make it clear that personal service, to make sure that these individuals have notice of the proceedings and can participate. If you look,
Yeah. Sure.
Judge Zone, how would you identify who? I can see that you could identify owner or co-owner, but how would you identify the regular user in order to notify them? Because I drive my neighbor's car all the time. Am I a regular user? I mean, I borrow his car.
that's an open question. And that's going to be up to the parties, the courts and the parties to have to navigate. What does this term mean? It's a new term in a statute. If that new term is not defined, one of the rules of statutory construction is that when we have terms that are undefined, you look to the dictionary definitions. But that regular owner, I suspect you would have a lack of clarity and potential differing views on what that means.
Okay.
Does it mean monthly, weekly, daily?
Yeah.
Yeah.
Okay, yeah, thanks. It'd
Thank
be
you.
hard to notify them if you didn't know who they were.
Yeah.
On page 9, on page 9, we're still in section 4243, and it's subsection D6. It says that an unlimited number of 30-day extensions of time may be granted if probable cause is shown and additional time is warranted. Probable cause for what? Is it probable cause for a criminal charge? Or is it probable cause to think that the property is subject to forfeiture? And the other question that the courts would have to wrestle with is, well, what's the standard for determining whether an extension is warranted? Is it good cause? Is it something lesser? And also, if the notice is a necessary predicate to the prompt post-seizure hearing, remember that hearing we talked about a few minutes ago under 4242A, if the notice is a predicate to the prompt post-seizure hearing, then does it make sense to have the state continually be allowed to get indefinite extensions of that time? Because it would seem to delay that prompt post-seizure hearing indefinitely.
Judge Zone?
Yes.
On 4242A, so it says that you have a right to a prompt post-seizure hearing, but then below it makes it clear that you have to petition for a prompt post-seizure hearing. Are those hearings automatic, or are they only held in the event of a petition?
They would, as I read the statute, they would only be held if someone requests it. You have a right, but that right is contingent upon you taking an affirmative action.
So in other words, if there were criminal interests didn't want to be involved with the court, say, they might not petition for a hearing. Whereas if somebody had a more legitimate interest in retaining a car or a house or something, they might petition for a hearing.
Yeah. Ben?
I think that's correct. That's how I would see it.
Okay.
Yeah, and a lot of specifically on the last point in about the unlimited number of extensions, initially in the passenger use version, that was, I believe, limited to one extension. And a lot of the testimony was, again, to try and accommodate I think the government, the prosecutors' sort of ability to investigate, and a lot of the concerns that I think the Department of Public Safety raised as far as sort of practical realities, but also giving the court flexibility to kind of handle things on its own. Now, that was, I think, what a lot of the testimony showed in the House Judiciary, and that's why that switched. But that being said, it could be changed back or can be tailored in another way.
Yeah, I'm having, as I read over the bill again, I'm seeing all of Matt Valerio's concerns and other witnesses' concerns, and now Judge Zone's concerns. So please proceed, Judge.
Right. And to be clear, I'm not weighing in on whether there should be unlimited or not. I'm just pointing out that
some problems with the House passed version of the bill.
And so then we have, if you go to page 11, for instance, on section 4244,
Yep.
It talks about that under subsection 4244A, the criminal division shall consider the loss of property subject to forfeiture as a criminal sanction as part of and following the prosecution into underlying crime. And section 4243D1 similarly says that the loss of property subject to forfeiture shall be considered as a criminal sanction as part of and following the prosecution of the crime that subjects the individual with an interest in the property to forfeiture. And so it's not clear to exactly how that is to be considered.
Yeah.
Are we to consider it as a sentencing factor? And the sentencing factors are under Title 13, Section 7030, which talk about the various sentencing factors that a court is required to consider. And so is this now taking a step to saying this should be included in 7030 and that the judge?
I think you've identified, Matt Valerio identified that as well, Judge. And I think clearly, if you owned $1 million home and it got seized, and we're gonna take that into consideration, and the person who owns a no more $25,000 home, but a person that owned a $100,000 home got seized, would we compare the two and then give the guy with a $100,000 home a longer sentence? Because he didn't have $1 million home to get seized.
Right.
And so I do think there's an
I
issue
think
there
that's a
with,
real problem with the bill.
Yeah, I think there are a lot of real problems.
I do too.
and so again, I think that I would join in the idea that it's a question about how we do consider it, and is it a sentencing factor that rises to the level of the
I don't see
7030
how it
factors?
can be a sentencing. I don't see how it can be a sentencing factor. That just begs unequal justice.
And I would note that when you look at the bill as a whole, there are quite a number of hearings being established. The prompt post seizure hearings under 4242A, forfeiture hearings under 4244, proportionality hearings under 4244, lien holder hearings, and innocent owner hearings. In other words, there's a lot of hearings that are going, if implemented, would be going forward in the courts. And if it's a policy decision that these hearings are ones that the legislature deems necessary and appropriate, obviously the courts are going to hold the hearings as we're required. But I would note that if we're going to be having these hearings, it puts a lot of docket pressure, if you will, to an already tough situation in terms of trying to address backlogs coming out of the pandemic. And so I would point that out. Also, under 4244 subsection C4, let me try to, that's on page 13 at the bottom. It says the criminal division shall not consider the value of the subject property to the state in determining whether the forfeiture is unconstitutionally excessive. Not really sure what that is intended to address. So I think there's a lack of clarity there as to exactly what that's supposed to be going towards.
What is unconstitutional?
Ben has a response.
Yeah, the testimony was that addition was to say that however the state values the property shall not be a consideration. It really would be the value in compared to the interest holder, the owner, or the regular user.
I'm
Okay.
going to make a radical suggestion here. If the current system has needs to have some changes in order to make it work, the current system that we have, my suggestion is that we get a copy of the current procedure and the current system without this.
Yeah.
And that we look at that and start all over again and listen and hear where the problems are with the current system and look at it to see, instead of trying to figure out what's here, let's look at the current system and where the issues are that people don't think it works and start over.
I think that was my attempt with the Department of Public Safety, to start with them
Yeah.
and work with the treasurer's office, with the judge and the defender and all, and see what improvements we can agree on the current system.
Yeah.
But if, again, this is a House passed bill. So it has already been approved by the other body. So, I'm happy to try to do that, but time-wise, we don't have a lot of time.
I get that.
So if people have, I would prefer to change the current forfeiture statute. Which, as I said earlier, I can remember reporting the bill, and I can remember one thing that Lieutenant Daniel mentioned was the amounts that go to the state versus the general fund, etc. That was all compromised between the House and the Senate. That's how they got there. It was, flip a coin.
I'm just not sure, and I haven't been, where this bill comes from and what the
Well, maybe
impetus for it is.
a judge, are you kind of okay with that? you've identified enough problems for us to be convinced the bill would not work as currently drafted.
Right. I had some more, but I will hold them back.
Okay, let's see if we can get a redraft. Lee McGrath, the Institute for Justice.
Mr. Chairman, members of the committee, thank you for the opportunity. I'm honored to be with you. And if I've provoked universal opposition, I must be doing something right in terms of finding a process and a document that strikes the compromise. Let me start by suggesting that crime should not pay, and that it is a legitimate function for the state of Vermont to confiscate the fruit and the instruments of crime. And so at the heart of this bill is that idea, those ideas. And secondly, a core principle of this bill is to respect Vermont. And in 2015, you passed a law that requires a conviction in criminal court as a prerequisite to civil forfeiture. That is the policy of the state of Vermont. It reflects Vermont's values that are different from the feds. It reflects a desire a recognition that this committee matters, and that those who want to outsource all cases, many cases, to the Fed are attempting to circumvent this committee's authority. With that in mind, Mr. Chairman, let me just make a few observations based on the conversations that and the testimony I've heard over the past couple two sessions. One is about size. There's suggestion that forfeiture, the way it's used in Vermont, is an important law enforcement tool. But we know that the median forfeiture across the nation is $1,300 in currency. It is not hundreds of thousands of dollars. We don't know the exact number because so few forfeitures occur under Vermont's state law, but we know in Connecticut, the median currency forfeiture is $655. And in Pennsylvania, it's $369. So this bill, and the reason it passed out of the House unanimously, the House Judiciary Committee unanimously, including the vote of former police officer Norris, is that it is targeted at solving problems associated with small seizures under and innocent owners. In that regard, it does not restrict law enforcement's continued collaboration with the federal government as it relates to joint task forces. So many of the concerns expressed about opiate deaths and things like that are not going to be, law enforcement's hands will not be tied. The only extent that law enforcement's hands are tied is it relates to adoptions. Adoptions are where Vermont law enforcement only makes the seizure and then calls up the U.S. attorney and says, please adopt the case. In 2018 through 2020, on average, there were 7 of those. They average less than $4,000. So the desire among past testifiers to cut out that minor restraint and instead, what this bill does, put it into Vermont courts with Vermont values, that concern is a bit overstated given the reality of the fact that so few adoptions actually occur. Mr. Chairman, you previously expressed concerns about leased cars and rental cars, and those concerns are addressed through the lien holder. So a person who, Avis or a leasing organization can get back their cars. That was an astute observation, and the bill takes that into consideration. You also address concerns about a child getting a house, and the child could get the house if the child is a owner of the house and go through the innocent owner process that's also in the bill. The public defender expressed some concerns about an additional way in which law enforcement could seize property. This was a concession that gained the support of the state attorney, and it was recognized as the same process that Vermont currently uses to secure crime scenes. And so this was not a big deal. The public defender also talked about abatements, about what happens when someone dies, and that the wife or relative could get that property back through the innocent owner. He seemed to suggest that they should go automatically to the wife or relative. That would mean that there'd be no restraint on the wives or drug dealers not even having to show up in court. I was encouraged by the comments by Mr. Daniels in his testifying about saying that the thresholds, like the public defender, are too low. We certainly would be open to raising those thresholds, but don't include this provision unless there is a direct criminal arrest. That is a restriction without that undermines the entire idea of a threshold. Similarly, your antenna should be high when you hear testimony about there being legitimate seizures. Legitimate seizures are not a standard in law. This bill requires that law enforcement have probable cause before it can seize property, and that prosecutors prove beyond a reasonable doubt that there is a conviction and by a preponderance of evidence. These are the real standards that should be at the heart of the way in which Vermont legitimately takes possession by seizure and takes title by forfeiture litigation. Certainly, there are opportunities to tweak bills to get processes more clear. I had hoped to meet with Judge Zona, but he was not available when I offered to meet with him. And similarly, neither was Mr. Pale when I exchanged an opportunity an interest in meeting with him. But at the heart of this bill, Mr. Chairman, is that you matter. Your laws in Vermont are important. They shouldn't be circumvented at the will of law enforcement and federalized. And that's what they are currently doing. And in a moment of magnificent candor, one of the early testifiers admitted that the problem was that the federal government pays better. The federal government pays 80% versus Vermont paying 45%. So with that, Mr. Chairman, let me suggest that the objections that you've heard mostly today are not reflective of the facts and the principles that Vermont uses that were at the core of what the House considered. And those are that Vermont is different from the federal government. The defendant has rights in Vermont, And so does his wife, his girlfriend, a spouse, a neighbor, innocent owners, and lien holders. And this bill addresses all those rights in a constructive way, in a way in which Maine has used and passed a similar bill in 2022. Nebraska, 2015, the border state of New Mexico, the same year, and long in North Carolina, since 1994, there has only been criminal forfeiture. Vermont's principle of requiring a conviction stays. All that's being changed is where that subsequent forfeiture litigation takes place, and it should take place in criminal court, the same court that hears the conviction. With that, Mr. Chairman, I'd be happy to answer the committee's questions about my law firm, the fact that we've been in front of the United States Supreme Court in Timms v. Indiana on the question of proportionality, or about these bills, about this bill, as well as the processes that are modestly changed to get the venue right. Thank you, Mr. Chairman.
Hey, thank you. I appreciate your work on this. I guess I was mistaken. My information was that the bill had been worked on by a couple of members of the House Judiciary Committee and had the full support of the Governor's Office and the Department of Public Safety.
Mr. Chairman, Representative Rachelson and Representative Loeffler were key advocates of this bill. It had bipartisan support from both of them. Chair Grad was a co-sign, and I had the good fortune of working with the state attorney's office and with Ben to update the current forfeiture statute to reflect this change in venue, the change from civil court to criminal court in as practical a way as we could.
Okay, I clearly, if we're going to go forward with the bill, there needs to be change. I appreciate your framing the issue for us, which appears to be current law in Vermont has a number of problems, and one of which is the requirement of a civil conviction, a criminal conviction, in order to go through a forfeiture. That's basically, so let's see how we can make this work in the limited time we have left.
Chairman, I'd be happy to continue to work with Ben. I've long been open to engaging other testifiers in addition to Mr. Meehan, who was very cooperative and I enjoyed working with. The core issue is that Vermont has a policy. It requires a conviction as a prerequisite. That's our goal, to keep that. But it subsequently requires that the forfeiture litigation be held in the wrong court system. It should be held in the same court system where a person who is indigent can get representation, and where a plea bargain can be had, where a judge who had heard all the evidence in the criminal court can make an easy decision about whether the car was an instrument and the cash was the proceeds.
I think I've got the gist of what we'd like to change, or what you'd like to change, and what the House is going for. But I think unless we can miraculously narrow the scope of the bill and try to respond to the concerns of the Defender General, the Vermont State Police, the Vermont State Attorneys, and the Vermont Judiciary, it's kind of pointless to go forward. I mean, if you got that many people opposed or with concerns about the bill, I don't know what there's much point going forward. So with that, I would thank you very much for the testimony. It's very helpful and clarifying to get us to a point where we can just move forward with that goal.
Mr. Chairman, I'd be happy to work with other parties in Vermont, as I have traveled there a couple times now to testify in the House. The task is not as large as it might appear, because you do have a workable statute that just needs to change venue, and to clarify some of the issues that the public defender and Judge Zona have raised. I would be cautious, if I could, Mr. Chairman, to suggest that we already have the sign off of Mr. Meehan on the process, and that the testimony you heard earlier this morning wants license to completely circumvent state law and outsource everything to the federal government. And we've identified that those are only 7 cases that they think are being restrained. So once again, I'm happy to continue to work with the stakeholders to get the wording and the processes right.
I appreciate that, but thank you very much, Lee. We're going to go on to John Booth, who represents the Vermont Treasurer's Office.
Good morning. Can you hear me?
Yes, we cannot see you though, John.
That is correct. I'm working from home today, and unfortunately, I don't have a camera available.
Oh, that's all right. You did provide us with a document on our webpage that, if you wanted to go over that or whatever your testimony is, we're happy to hear.
Sure. So for the record, I'm John Booth. I'm the Director of Treasury Operations at the State Treasurer's Office. And Ashlyn Doyon, our Policy Director, is also on the meeting this morning. So thank you for making time to hear from the Treasurer's Office about this bill. I'm not here to talk about the process and the technical points of how we get to a forfeiture. I'm here to talk generally about the section of the bill that deals with receipt, custody, and distribution of the forfeited property, which is section 4247. So currently, under the current statute, the funds are delivered to the Treasurer's Office, and we're responsible for receipt, deposit, accounting, and reporting, and information requests as they come along. We do occasionally receive public records requests. I think typically people are doing research around the country, and they include Vermont. So as you've heard, and as you can see on the handout that you have, there have not been many forfeitures done under the existing statute, and most of them were done in the early days of the current statute in 2016 and 2017. So there is the current balance in the fund, as you can see there, is $17,152.95. Some of the funds that are being held have not yet passed through the civil forfeiture process. So they're pending forfeiture in some cases. And the distributions that have been done from these funds to date have not been the result of the forfeiture process. They've been determined to fall outside of the regular distribution in the statute. And so they've been dispersed according to instructions from the Attorney General's office or the state's attorneys and sheriffs to date. And so what we wanted to talk about is the fact that whether you continue with the new bill or go back to a review of the existing statute, we feel it's not the best place for the Treasurer's Office to be the custodian of the funds and to be the place where the determinations of how the funds are to be distributed are made. We think that would be better off, more effective and more efficient if that were to reside with an agency or department that works regularly with the law enforcement agencies that would be seizing the funds and handling the court proceedings. And so that was the point of our testimony this morning, was just to suggest to you folks to consider having someone that is in a better position and has more expertise in these matters, working with law enforcement on the forfeitures, and the business offices in the agencies or departments can handle the receipt, deposit, and accounting and disbursement of the funds or tangible property if that were to be received. There hasn't been any tangible property received to date. And so those were the comments that I had for you this morning.
Okay, thank you, John. So
Everybody loves this bill.
yeah, I've never encountered a more popular bill that's passed another body. I'm sure they do this to us over there. I wonder how the hell it got passed.
Right.
But I'm just dumbfounded. So I think what we'll do, I thank everybody for the testimony this morning. And then the goal is to change current law to allow civil forfeiture without conviction. That's the stated goal of the bill. How do we get there without so many confounding issues to have the judiciary, the state police, treasurer, defender general, all in with concerns about the House passed version. So that's the goal, and I'm going to give it a week.
Mr. Chairman, if I might.
No, I've had enough. I've had enough. You know, I'm trying to close up here. I got to be done in 5 minutes.
This is our bill.
This is how it works.
Chair, so it's just a point of clarification. So we want to maintain the civil forfeiture statute and clean it up, or do the transition?
And allow and change where the money goes. Maybe figure out that with working with the treasurer, work with the Department of Public Safety on suggestions, and work with Judge Zone and Matt Lario and Evan Meenan on suggestions for making it a simple bill that updates current Vermont law to allow civil forfeiture.
And with that in mind, I do think that the bill would be dramatically reduced and narrowed, where it would really just be, instead of conversion to a total criminal process, where you're just amending certain parts of
Certain parts of
the
current law that are not, obviously are not working. Given the documentation from the treasurer and the testimony from Lieutenant Daniel of the Vermont State Police. Joe?
It's been 20 years since I was looking at a forfeiture case, but back then, the AG's office had specifically designated an individual as the one who ran around collecting, and I wasn't here for Fridays.
Yeah, I think probably the Attorney General, because they do, you know, they get a settlement from Monsanto. They put it into, you know, portion of it goes to the general fund, portion goes to the.
I'm just wondering if that person or that job title still exists within the AG's office.
I don't know.
There's also the,
That may
in our
be
new
the end result of
agency.
why you're not seeing much here.
in our new agency of public safety, there is an office of support services that deals with finances.
But on the other hand, the Attorney General, that's a good
Yeah,
suggestion, because the Attorney General does that routinely
Right,
in civil
In-
settlements.
yeah.
And
And they'd be a neutral.
yeah, a policy consideration, I think that you're getting towards was, does the committee want a more neutral party or one that may have been involved in?
Well, I mean, it would go, if it was Bennington's case here, where is the Bennington case? Since I love to use Bennington as an example.
I don't know how you can even read that.
The Bennington Police Department, 2417, $3,658. Looks like that's been still in the treasurer's office. So how do we get it out of the treasurer's office into the town of Bennington? and their portion and everybody else's, but, so it seems like the Attorney General office would be a good place, but we should probably check with the Attorney General's office to make sure they want it, but clearly the treasurer doesn't want it.
There is an optics problem about the law enforcement agency that's involved with prosecuting somebody actually pursuing the money at the same time.
And I think that's why we put it in the treasurer's office. to
But
begin with.
but that was why it was changed, the percentages as it left the Senate. The 2015 bill that Mr.
Yeah.
McGrath spoke about, as it left the Senate, I believe it was more similar to the federal
Mhm.
breakdown. And the House wanted it changed to a smaller amount to the local police.
Yeah, and those amounts haven't changed in this bill.
So
It started out as.
anyway, I think we need to go